The next case is In Re AC, GC, and SB. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Judge Lanzinger, Your Honors, may it please the Court, Andrew Karras on behalf of appellant, mother to the children, Michelle Bond. I would ask to reserve 3 minutes for rebuttal, if I could. The state's interest under Section 2151.04 of the revised code arises only if no one is meeting the obligations of care, support, and custody which are owed by the parent. That's language taken from this Court's decision in OH, which we've cited in our brief, and OH is one in a string of cases that stands for the premise that if a parent is temporarily unable to care for their children, there is no dependency if they identify an alternative suitable caregiver in their stead. That's what happened here, I would submit, and for that reason, we would ask that this Court vacate and remand. The factual distinction here really between this and the cases we've cited in our brief, OH, OV, TD, DH, and others from other jurisdictions, are that here there is essentially an intermediary identified resource. So mom gives the children, at the time she is pink slipped, when she is hospitalized, she tells the staff at the hospital, my adult daughter can take them. The adult daughter then does take them. The kids are excited to be with her. Everyone deems her appropriate for that limited purpose. And then adult daughter then identifies paternal grandmother for SB and the father for the girls as more long-term placements. Even though that is a factual difference between here and the other cases we've discussed, I would say that it's not a difference that speaks in any way to the logic of those cases. So just quoting from some of the language in OV, a decision by this Court just last year, the police, so here the nurse, asked mother to identify an appropriate caregiver for the child. The police, here the nurse, had no concerns about that caregiver's suitability. CSB presented no admissible evidence of that caregiver's unsuitability, and assumption of care was not based on a prior arrangement by CSB. So, to be sure, this Court has held that it's not enough if a parent merely hopes that the resource she identifies is going to take the child or the children. Also, if the agency arranges for this prospective caregiver involvement, then the parent doesn't avoid a dependency determination in that circumstance. But that's not this case. This is, like I said, there is that slight factual and chronological difference between this case and some of the others, but...
Well, counsel, were the children adjudicated dependent because mom was unavailable due to her hospitalization, or were they adjudicated dependent for other reasons?
Sure, so so I'm happy to turn and talk to some of the other environmental or conditional reasons that the trial court relied on.
Right, because I mean, if we're going to follow In Re OH, we would have to say, wouldn't we, that the children were adjudicated dependent because of mom's unavailability to care for them because of hospitalization.
Sure, so turning to, I mean, the other kind of conditional circumstances that I think gave rise to the dependency adjudications and that the agency in its own brief has defended the adjudications are mom's mental health concerns and the history of domestic violence between SB's father and mother. So to speak to mental health, I think importantly, at least with respect to subsection B dependency, is that there was no clear and convincing proof of a condition. So
is it the condition or is it the behavior that's the issue? Because when you have a behavior like delusional thinking and it affects eating, for example, or not example in this case, does it matter that there's a diagnosis? Isn't it about whether the mother can adequately care for her child?
So arguably under subsection C, I think that's right, but at least with respect to one of the statutory bases of dependency here is there does need to be proof that the child lacks adequate parental care by reason of the mental or physical condition of the child's parents, guardian, or custodian. So we've cited cases that hospitalization alone is not proof of a mental condition, and mental conditions, according to the OH decision, again, this is paragraph 27 to 28, are not matters for lay speculation. So here, and again, with respect to that specific statutory basis, I think that kind of is the entire ballgame under B dependency, because there is no evidence of a medical diagnosis, no physician testified. The nurse who did testify disclaimed the ability to make diagnoses, and she made kind of offhand references to things that might be in mom's medical charts, but didn't say specifically what those were, and those charts, to be clear, were not offered or introduced.
I guess my question was, where is there a requirement of a mental health diagnosis in order for there to be dependency? It sounds like it's a condition, or it is lacking adequate care, being able to provide adequate care for the child. So that's more about the behavior, right?
I would submit that under the case law we've cited that there does have to be, a mental condition means mental condition with some, credible medical proof. But setting that aside, because I would concede that that's not explicitly a requirement for subsection C dependencies, at least. I don't think there was the requisite attendant impact on the children or their environment here. So Nurse Hall, this is transcripts, the transcripts at page 18 said all 3 children appeared fine. Officer Dyes, who responded to the home in October of 2023, indicated that he thought the home was ordinary and free of hazards. Paternal grandmother described the house as clean, said that the children eat as you would expect children of their age to eat.
Mom herself said that she had thrown out the food, right, because she thought it was contaminated, it was poisoned.
So, yes, and
so at least at one point she was not feeding him because she thought food was poisoned.
So I don't think the record reflects that she was not feeding them. She did not feed them that specific food, and there are, to be sure, facts suggesting that mom's, I'll say, strange beliefs manifested themselves in behaviors that were.
What about the kids locking themselves in the closet to keep themselves safe?
So it's not clear what the caseworker based that testimony on. When or how many incidents there were. That was a question that was the question that elicited that line of testimony. It was just one, almost a side line of testimony. Was in the hypothetical, what kind of concerns does domestic violence in the general sense pose to children in this household? And that's where she mentioned that. It's not clear who the source of that statement was, whether that's something the children told her, whether that was something that was at issue in the prior dependency case that was later closed. So I would submit that that is a bad fact that I need to get around from my side of the V perhaps, but it's not clear and convincing proof of a home, as the agency describes it, marred by domestic violence.
Well, in conjunction with that testimony, isn't there concretely a pending domestic violence case and protection orders in the law?
I think that's right, and this court has said that in a home where children are exposed to a long history of domestic violence, they are dependent. That said, so for instance, compare this case with this court's precedent in JG. That case, which I think is a kind of holotype example of domestic violence being a reason to find dependency. There was a cohabitating dad and stepmom who lived together in the home with children. That's not the case here. SP's father is a non-custodial parent. He is precluded, legally speaking, from seeing mom and SB under the terms of the orders entered in that criminal case. In JG, the case was initiated after a weekend of continued quarreling between father and stepmother, during which stepmother threatened to commit suicide, and sheriff's deputies were repeatedly dispatched to the home. So just factually, I think this is not that case. Here what we have is an instance of domestic violence in October of 2023 that Officer Dice responded to. The record doesn't reflect that the children were present when that happened, and Officer Dice reaffirmed that on redirect. question was, you said the children were with the neighbors. Do you know where they were during the altercation? And he says, no, I do not. She had stated that when the altercation had happened, that she just ran to her neighbor's house. She never stated where the children were located, but they weren't at her house. That's taken from page 26 to 27 of the transcript. So the other evidence of domestic violence comes from Officer English, who responded to the house in March of 2024. And that was not, at least on this record, in response to any specific occurrence, but based on a request by Ms. Bond that she get some resources to help her with domestic violence. She didn't specify SB's father as the person for whom resources she was seeking. Maybe you can presume that he was. But again, to the extent that domestic violence was a concern to the safety and well-being of the children, the record reflects that Ms. Bond was taking steps to address that, I would submit. I have, about a minute left before I'm into my rebuttal time. So just the other side I want to make mention of. So the state hasn't, in its own brief, specifically defended the adjudications on the basis of mom's alleged substance use. I would submit that this court shouldn't do that either if it were so inclined. There's no actual evidence, at least in this case, of illicit drug use. There's a caseworker statement that in the prior dependency case, there were concerns that she might be using substances, specifically meth, but that she was negative on her screens during the proceeding of that case, and that case eventually closed.
I was going to ask about that. Did she admit? I thought the argument was that she had admitted that she used meth. But not her screens were negative, but that she uses meth or periodically uses meth. Is that the correct statement?
So there's no admission to that effect, to my recollection, at least in this record in this case, as it relates to this case. There was a statement by, there's testimony from the caseworker reflecting her interview with Dad, SB's father, that he thought mom could be, I'm quoting from the transcript there, he thought that mom could be using meth again, but it was qualified in that way, and there was no actual evidence proffered in adjudication of use.
So you're saying in this case, she's never admitted that she's using meth?
To my recollection, that's
But she may have admitted that in the other case.
Correct, which was where her screens came back negative and the case was subsequently closed. So I would submit that as it relates to use, that whether or not use is established, there's also not an attendant impact. There's no indication that use occurred in the children's presence or in a way that affected their home environment. And so for those reasons, we would ask again that this court vacate and remand either for further proceedings or for dismissal, depending on which legal basis you think is appropriate. And with that, I would reserve my remaining 3 minutes for rebuttal.
Good morning, Your Honors, and may it please the court. My name is Aaron Campbell, and I represent Summit County Children's Services in this matter. Children's Services respectfully asks this court to affirm the decision from the trial court below that adjudicated these children dependent under 2151.04B and C. Now, in contrast to Mother's argument here, the agency's position is that this case is not one where the decision rested simply on parental unavailability due to hospitalization.
So what did the complaint actually allege?
The complaint had alleged that there were concerns regarding bizarre mental health in the home. There was a history, ongoing domestic violence concerns. And there was an incident where Mother was pink-slipped again, and that's what led to this case, and she was in the hospital. So there was that direct unavailability for the mother, but that there were also other concerns in the home that led to this finding of dependency. And the trial court's decision noted several concerns that they were primarily domestic violence, the mother's mental health, the bizarre behaviors in the home, and there were some concerns of drug abuse actively in the home as well. Now, primarily the domestic violence, this was something that the trial court went into great detail. It was spent several paragraphs in its decision addressing the concerns that were presented regarding domestic violence. There was the incident in 2023 where the police had to be called That led to the charge of domestic violence and the protection order that protected not just the mother, but one of the children in the home as well. That also led to a charge against Mr. Powell for violating that protection order. There was also testimony presented where Mr. Powell admitted that he was openly violating the protection order by contacting the mother regularly, having phone contact and in-person contact. The mother also admitted that she was openly violating that protection order by relying on Mr. Powell for transportation. So, despite his mother argues today that she took appropriate steps to address the domestic violence, that's not supported by the record. The record demonstrates that the domestic violence was an ongoing concern. Parents were openly violating the protection order, and it was having a negative ongoing impact on the children. There was testimony that the caseworker stated that the children had seen fighting between the parents and that they had to hide themselves in the closet during this fighting. Now, this was not addressed by mother in her brief, and she tries to argue and reply in oral arguments today that that was not sufficient for clear and convincing finding of domestic violence or dependency in this case. But that wasn't raised in the mother's brief, and she cannot argue now in reply or in oral arguments that that was insufficient for the finding in this case. That was, since she did not raise that argument has been forfeited, and domestic violence in this case was one of the primary concerns relied upon by the trial court correctly in this case. It's something that was having a negative impact on the children, and so therefore this court should affirm the decision on that basis alone. But if this court is going to address some of the other concerns raised by mother, this court should also reject those arguments. Regarding the mental health diagnosis, under 2150-104B, that does not require, the plain language there does not require evidence of a diagnosis. It specifically says mental health or physical condition. If the legislature had intended for a diagnosis, evidence of a mental health diagnosis to be presented, the legislature could have made that requirement in the statute. It did not. So a mental health condition can be documented by lay witnesses, and that's been supported by this court's history and interpretation of dependency B and C. Primarily, as I cited in my brief, this court's decision in re JM looked at very similar facts in determining and supporting a finding of dependency B and C regarding domestic violence, drug use, and mental health concerns. Those are very similar to what we see in this case. In JM, this court explicitly stated that a parent's impaired mental health can be demonstrated by evidence of erratic behavior. And that erratic behavior for mental health specifically includes drug abuse or ongoing domestic violence. As domestic violence and drug abuse, those are also mental health concerns.
So even if there is a mental health concern or erratic behavior, don't you also have to show that that's affecting her parenting ability?
Yes, Your Honor.
Ability to provide adequate care?
Absolutely, Your
So
Honor.
in this case, there wasn't any evidence that the kids were malnourished or not eating food. So where's the nexus there?
Well, adequate parental care is defined as adequate food, clothing, and shelter. And I believe there was sufficient circumstantial evidence showing that the children were not receiving adequate food or shelter. That there was substantial evidence that there was the food was thrown out. Mother had thrown out all the food in the home and it damaged the refrigerator in the home because of paranoid delusions. She thought they were being poisoned by her relatives.
If she was in a domestic violence situation, isn't it possible that she could be poisoned?
I wouldn't preclude that possibility, but the evidence wasn't that was happening. And in fact, I believe the testimony was that she thought the grandmother was poisoning her food, and that was the grandmother was someone up until that point she was relying on as a resource to care for the children, as well as to provide groceries in her home and transportation. But the delusions went beyond just the food in the home. There was testimony that she told the children to stop brushing their teeth because she thought the water was being poisoned. And She had also blocked out the windows with blankets. She had taken out the light bulbs because she thought they were listening devices. So there were concerns about the negative impact of the shelter itself and how her delusions were impacting that care for the children. Additionally, the hospital testified that though they didn't have physical concerns for the children, they did have to feed them. They provided food because the children were hungry when she was ultimately pink-slipped. So there was evidence demonstrating some impact to food, clothing, or shelter as a result of her mental health conditions. Now, I would also point out that it was not a limited circumstance, or this didn't just happen over one or two isolated incidents. There was testimony that her bizarre paranoid delusions had been going on and on for a period of about 4 years, and that had manifested itself into the conditions that we saw that led to this case. It was not merely an isolated incident, but it was something that had been going on for a period of time. There's also a public policy argument here for this court to consider. If this court's going to only consider evidence of medical diagnosis of mental health, then that's going to have a negative impact on parents seeking treatment when they have significant mental health concerns that are impacting their children. If a parent knows that going to the hospital that's the only thing that can be used against them in order to have the state be involved with their children, that's going to deter parents from seeking treatment. And that's not something that the legislature intended with this statute, and that's not something the court should read into that language. We want to encourage parents to seek mental health, especially when it's having a negative impact on their children, like in this case. So we would ask the court to reject the argument from Mother that evidence specifically about the mental health diagnosis or some medical testimony is required under a mental health condition. And just lastly, I would address the argument about this case being mere parental unavailability. This case is very distinguishable from in re OH and in re OV. This was, in those cases, in re OH, that was just, there was a lone concern about the parent's unavailability due to alcoholism, but that was never proven in OH, and there were no other surrounding circumstances demonstrating the concerns for those children in OH. And that was very similar in what happened in re OV. The lone concern was the parent's unavailability due to arrest. The facts of the underlying arrest were never presented in that case. But that's very distinguishable from this case, as there were multiple witnesses who had testified to the parents, specifically the mother's mental health concerns, as they had been affecting the home for a period of multiple years. We had relatives testify, there were deputies who had testified, the Jacksonville police had testified, the multiple witnesses in that home demonstrating that these erratic behaviors had gone on for a period of time. It was not merely just the unavailability of the parent in this case. But there's also a concern that even if this court considers that specific unavailability, in this case, what we're talking about is the parent was pink-slipped and really just identified her adult daughter to care for her child. There was no thought for how long that care needed to be provided. There was no discussion about child support, medical arrangements, any authorization that her daughter may have needed to care for those younger children. And those are evidence of a parent's plan for care of the children. What we're talking about here is that the parent had just merely identified someone who could possibly take care of her children while she was going to be involuntarily committed. Now, that might be an instance where that's an appropriate arrangement, but we see in this case, even that wasn't appropriate because that adult daughter could not care for those children through the duration of her hospitalization. The adult daughter had to go to the paternal grandmother, who was the person who had a falling out with the mother in this case because of her paranoid delusions. She thought that the grandmother was poisoning her, and that the daughter in this case ended up leaving those children with that relative. So it doesn't seem that the mother in this case made a plan at all. And even if she had, that plan was not adequate because that wasn't the arrangement that ultimately led to care for these children. If we accept the mother's argument that just any random person can provide care for a children and that's sufficient to avoid a dependency finding, well, that allows a parent to just simply abdicate their parental duties so long as any person is providing care for the children. And this court directly rejected that argument in In Re JM. In In Re JM, the parent had left the children with the grandmother and walked away, stopped visiting, stopped providing any support, provided no medical hospital authorizations, no school authorizations. This court directly stated that a parent cannot abdicate those parental duties and walk away, leaving a child with even a relative, even if that relative is providing adequate care. When we're talking about a plan, that actually needs to be a plan. And that's not what we saw in this case. The children were just left with a relative in the hopes that the mother would get better in the hospital. But as we see, this was something that had been going on for years. There's no reason to believe that that plan was going to adequately solve or remove the children from the home where the domestic violence has been occurring, these bizarre mental health behaviors have been impacting the children, and there was also testimony of some drug abuse. To address Your Honor's question regarding the drug abuse as well, my understanding from the record is that between pages 93 and 94 of the transcript, that the mother had admitted to the children's services worker that it was her most recent hospitalization. She had taken a drug screen there, and that she had admitted to the children's services caseworker that she had relapsed on methamphetamine. My recollection is that was a recent use and not something that was historical. So yes, in this case, this is not a mere parental unavailability. This was a case where that had been marred by domestic violence, bizarre behaviors from mental health, and drug abuse that had negatively impacted the children. And the court below correctly found that those children were dependent under B and C of 2151.04. So we'd ask this court to affirm the decision of the trial court below. If there are no other questions, I would rest. Thank you, Your Honor.
You'll have your full 3 minutes.
Guys, I'm going to try to make 3 quick points. First, as it relates to the argument about forfeiture of the issue. In our opening brief and below, Mother disputed in general terms whether there was sufficient evidence to support a dependency adjudication and whether the dependency adjudications were against the weight of the evidence, and articulated reasons in both her objections to the trial court and the opening brief to this court why the evidence presented didn't support those adjudications. Reply briefs, under this court's local rules, are primarily, the primary purpose of them is to address things that are not raised and covered in the opening brief. So I would submit that we are allowed to dispute whether there is sufficient evidence of domestic violence or whether the evidence that does exist of domestic violence in the household nevertheless cannot drive a dependency award under weight principles. The point about mom's lack of longer-term plan, that she didn't articulate how long Ms. Lenke would be able to care for the children, that she didn't make arrangements for a child support order, that she didn't execute powers of attorney documents. Those are all interesting arguments that are unmoored from the reasoning in the long line of cases that we've cited. If OV didn't require that, OH didn't require that, neither did any of the other cases we've cited in our brief. In fact, OV involved a term of incarceration, an open-ended term of incarceration by mother. There was no evidence on the record whether she had bonded out by the time of the adjudication or when she might finish serving whatever sanction might have resulted from that criminal case. And so I would submit that it would be unwise to impose into that line of precedent a requirement that a parent undertake a litany of legal hurdles before they're allowed to leave their children with another caregiver and avoid dependency by doing that. Finally, the point that the policy argument about whether it would deter a parent from seeking help to require proof of a mental health condition as part of a subsection C dependency prosecution. I don't think that answers the plain text of the statute. Again, that requires that a child lack adequate parental care defined as inadequate clothing, food, shelter by reason of the mental or physical condition of the child's parents. And that's straightforwardly something, that condition is straightforwardly something we don't have on this
But
record.
condition can be a result of drugs, and we don't necessarily have a diagnosis, like stimulant psychosis is something common with methamphetamine. So we might not have a diagnosis for behaviors.
Sure,
So
and
that would be a practical problem. It would be a mental health condition, or it would be a mental health, something stemming from mental condition, but it's not necessarily a psychological diagnosis.
And I don't think it necessarily needs to be, certainly under subsection B, but on this record, I don't think you have, the condition of, illicit drug use and condition.
So wouldn't that be a high burden to make a diagnosis of some sort?
It could be. On the other hand,
In
it's
contradiction to the plain language as well.
in contradiction to the plain language and in contradiction to the reasoning articulated by this court in OV that mental health conditions are not the province of lay speculation. So with that, we would ask for reversal and remand as outlined in our briefs, and I thank you for this.
Thank you. Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. This court is now adjourned